Good morning, everyone. Thanks for joining us. We're going to give everyone just a couple minutes to get settled. We'll start pretty quickly after the hour. We are waiting for our ASL interpreter who has had to reboot. So she is getting back on as quickly as possible. We do have live transcription services for the time being. There we go. Welcome back, Callie. No, perfect timing. Very good. Very good timing.
Technology is great, except when it's not. I'm sorry.
No, we appreciate you. Okay, so for everybody, we have our ASL interpreter is back with a working camera. Thank you. And again, but we still have the live transcription services as well. And I'm going to go ahead and get started and tell everybody thank you for joining us today for our third DRSC University session. Today, you're going to be hearing about accessible housing, reasonable modifications, and reasonable accommodations. So I'm just going to go through a couple of housekeeping matters first. You are being recorded. That is so we can put these sessions on our website and have those as a resource for folks who couldn't attend today. In that vein, we already have our first two DRSC University sessions up. The first one about guardianship and alternatives to that, and the second being on accessible voting. Those are both up on our website, complete with captioning for everybody's consumption. So please do take advantage of those. And within a couple weeks of this session, we will have the session up, and those can be forwarded and linked, and we want everybody to take advantage of those. How to ask questions. We're going to take questions at the end of the session. I am going to kind of field those questions from the chat. So if you're able, please put them in the chat. If you are on a device or something that makes that difficult, please raise your hand and I'll be glad to unmute you and we can do it that way. In the session, there are a couple of examples where you're kind of being asked to choose between two things. And we're kind of going to test you a little bit. And so please put those answers in the chat and I will kind of give our presenters the gist of what's going on in there. Again, questions will be answered at the end. There will be time for that. So please put them in the chat and or raise your hand. I think that's it for housekeeping. Can we go to the next slide, Phil, please? Our DRSC University schedule, we've got a 101 kind of intro to the ADA and the Bill of Rights coming up in April. We've got a great session about our service areas and what we do that will be conducted in Spanish in May, one about transition services in June, and then several coming in the upcoming months. So please do put those on your calendar. We've got links for all of those on our website, and they will be recorded and posted just like these sessions. That said, I'm going to let our presenters take it away. We've got Pete Cantrell, who is a senior attorney with us, Disability Rights South Carolina. And he's got a partner to team teach this session, Alyssa Barker. She's an investigator with the South Carolina Human Affairs Commission. Please take it away, guys.
Okay, thanks, Aaron. Next slide, please. So at Disability Rights South Carolina, we're a nonprofit and our services are free. We help people all over the state of South Carolina. We're mandated by both state and federal law to protect the rights of people with disabilities. We're an independent organization. We don't have to respond to any other agency that provides treatment or services to people with disabilities. We work for the people with disabilities themselves. And our mission is to protect and advance the legal, civil, and human rights of people with disabilities in South Carolina. And those of you who've been around a while, like I have, probably remember us as Protection and Advocacy, or P&A, but we're now Disability Rights SC.
And Pete, can I interrupt you real quick? I am so sorry. I forgot that we have to have a poll before we continue.
Okay.
This is the first time we've done this, so of course I forgot it. My apologies, Pete. And Phil, if we could go ahead and get that poll up. We would like to know if you, the viewer of this presentation, are a self-advocate, a person with a disability who's a direct consumer from us, a professional in the area, a family friend or a caregiver of a person with a disability, or anybody else's other, somebody in the community who's just kind of interested in this topic. And this helps us tell our funders who we're reaching, and it also helps us know who we're getting in touch with as well. So if you wouldn't mind to do that poll real quick, I'll leave it up there for just a second more. And apologies, Pete and Alyssa, for having to butt in. Give it a few more seconds. It looks like most everybody has answered. All right. Thank you, Phil. And go ahead, Pete.
All right. Next slide, please. So our services, information and referral, that's where we just provide information to somebody who calls in that might help them, or we refer them to other agencies that might help. Legal support. This could be anything from legal representation to something that I call self-advocacy support. Some of our funders call it that. I think it's one of our best services. That's where we help somebody understand their rights and understand how best to advocate for their rights on their own. Education and outreach, that's what we're doing here today. Monitoring investigations, that's really when we look into how people with disabilities are being treated. Are they being abused or neglected and often it's in an institution. And public policy advocacy, we advocate for public policies that benefit people with disabilities. Next slide, please. So disclaimer up front, housing, boy, there's a lot to know about housing rights. It's broad and complex. We're not going to cover everything today. So some things we're not covering is discrimination in advertising. NIMBY, don't put that group home in my neighborhood. That's a form of discrimination. Redlining doesn't happen so much with people with disabilities, I don't think, but it certainly has happened with steering people from different racial backgrounds to different neighborhoods when they're looking for housing. New construction guidelines. The Fair Housing Act has guidelines for accessible construction. We're not going to talk about that in any detail today. Federal housing regulations govern lots of different kinds of housing, public housing, Section 8, things like that. We're not going to talk about what those regulations say. The State Landlord Tenant Act provides a lot of rights and responsibilities to tenants, and we're not going to cover that today. Finally, evictions. There's a lot of policies and procedures and laws that govern the eviction process, and we're not going into that today. Next slide, please. So turn it over to Alyssa.
Hey, my name's Alyssa Barker. I am a housing investigator with the South Carolina Human Affairs Commission. If you don't know who we are, we call ourselves SHAC. You might hear me say SHAC. We were created by the General Assembly in 1972. The General Assembly declared that the practice of discrimination was unlawful and degrading, and that discrimination interfered with the people's opportunity to get employment and to develop according to their abilities. So our agency was created to enforce the state laws and to, as our mission says, prevent and eliminate discrimination in employment, housing, and public accommodations. We also try to foster a mutual understanding and respect among the people of South Carolina. In addition to our investigation side, we have what we call our prevention side, which is our community relations department. We are generally a civil rights law enforcement agency for the state. So that's my side is the, we call it the compliance side. We do the investigations. A little bit more about our services on the next slide, please. So like I said, we do investigations, training and outreach and education like we're doing today. Sometimes we're very lucky to partner with great other agencies and stuff like Disability Rights. Our Community Relations Council, they create community relations councils in different counties to try to foster that conversation among the people. When we find that there's been discrimination, we do litigation. We will sue on behalf of the state of South Carolina if someone has violated the law. Now, one big difference is that we do not provide legal advice or legal representation unless and until the agency does find that there's been discrimination. During the course of our investigations, we are a neutral agency and we cannot give any parties legal advice until it gets to the point that we have actually filed a lawsuit. Next slide, please. Now, the Human Affairs Commission in our housing department works with HUD. People sometimes call us HUD. We're not the same, but we do work with them very closely. We are what's known as a Fair Housing Assistance Program. And that means HUD provides this funding annually on a non-competitive basis. And we work with them to, from the beginning of a case to the closure, they look over all of our cases and make sure that they agree with the outcome. If they see something different, or if they see that they want to reopen it from a federal side, if there's a bigger scope, they might do that. The right to equal opportunity in housing is ensured not only by the Fair Housing Act, but by our state and local laws. The South Carolina housing law mirrors the federal Fair Housing Act very closely. So you'll see a lot of the same. We might talk a little. I know we're not going over federal law because it has a broader scope. But some of the same laws are written the same. Some of the federal laws and state laws are written kind of the same way, and they cover a lot of the same topics. Next slide. Just to jump into fair housing a little more broadly before we get into reasonable accommodations. The Fair Housing Act was signed into law April 11th, 1968. It's been updated a few times, luckily, and it now covers 7 protected classes: race, color, religion, national origin, gender or sex, and disability and familial status, which is households that have minor children or expecting minor children. The law was last officially amended in 1995 to add an exemption for that familial status, which allows housing for older persons to exist without minor children there. But there are some very specific requirements to qualify for that exemption with HUD. Now there's one more down there, and that's retaliation. The retaliation section of the law says that it is unlawful to coerce someone, intimidate them, or threaten them, or generally interfere with their fair housing rights or them trying to exercise their fair housing rights. And that includes someone that may file a complaint with us or seek assistance from another agency, or anyone who's even just encouraging another person to exercise those rights. It is illegal to retaliate against them for doing that. Retaliation can be pretty much any negative action taken for exercising their rights, from terminating a lease to charging fees to delaying maintenance, things like that. That can be pretty broad. And as far as retaliation goes, that's something that we can find that there's been retaliation, even if there was not discrimination in the initial complaint. That kind of stands on its own. Next slide, please. The kind of dwellings that are covered under the Fair Housing Law: apartments, townhomes, condos, homeowners and condo associations, shelters and group homes, nursing homes, college dorms, longer-term hotels. It's pretty much everything you can think of almost. The term housing provider in the law, courts have applied that to individuals, companies, associations, property management, lenders, insurance companies, and including state and local governments and colleges. In fact, a couple of years ago, the HUD and the Department of Justice settled with the town of Irmo here in South Carolina for a disability-related complaint. So state and counties can also be covered under this law. Pretty much anything housing and real estate related is going to be covered. Next slide, please. Say pretty much anything because there are a couple of exceptions. And that would be single family homes without using a real estate agent or management or advertising. If you're using an agent, then the law expects you to know the law and to follow it. The single family homes apply if the person owns 3 or fewer homes, and that it does include personal homes, not necessarily just rentals. So 3 or fewer homes would be exempt from the law. There's what's known as the Mrs. Murphy rule, which is basically boarding houses. Personally, I've never seen this exemption come up. I don't think it's as common here or currently to have boarding houses. But this applies to rooms for rent in a house that is also occupied by the owner. Again, that's more of a boarding house rule, and I've personally never seen it come up, but it is an exemption. There's an exemption for religious organizations, as long as it is not a property being used for commercial purposes. So things like sometimes religious organizations will have houses that they allow congregants to stay in when they need it, or for employees of the organization. As long as they're not being used for profit to the organization, they can restrict it to preference the members of the organization. And the last one is private clubs. As long as that is being, leased without commercial profit, they can limit it to their club members. And the other exception to that, the exception to the exception is that the club membership cannot be discriminatory. So if the club is itself being discriminatory in its membership, then that could lead to an additional discrimination claim and would kind of wipe out that exemption. Now, the last little note down there is no exemption for making discriminatory statements or advertising. Now, we're not going to get into detail about advertising, like we said earlier, but just know that if someone makes a discriminatory statement or advertises a preference that they will not allow service animals, or they only want a particular national origin or color, any of these exemptions go away. It could be the only house they own. If they are advertising a preference, then that exemption does not apply, and they could still be in violation of the law. Next slide, please. Prohibited acts. What exactly can they not do? These people, these landlords that we're talking about. It's refusal to sell, rent, or make available. And that term "make available" is very broad and includes so many different actions. This is not an exhaustive list. Making available kind of ties into all of these other things, because if you can't enjoy a house in general, even if you're still in it, then it's not really being made available to you the way that it is another person. So that making something available can be a very broadly interpreted term. Obviously, like I just said, they can't advertise a preference. Discrimination in terms and conditions is also a very broad phrase. And essentially, it's just treating someone differently, whether that's not doing their maintenance in the same time or applying policies to people differently. Terms and conditions, if people are being treated differently than another person for whatever reason, then that could be difference in terms and conditions. steering, like Mr. Cantrell mentioned earlier, guiding people to a certain area or certain property based on their protected class. Sometimes we see that with putting children in certain buildings, or people of certain national origins or race being guided to certain parts of a property. And we also see it with people with disabilities being told that they should only rent on the bottom floor when that was not necessarily requested. Some other things, sexual harassment is included as a prohibited act, along with that coercing, intimidating, and threatening, and just general harassment based on a protected class. And then finally, what we're all here for today is refusal to allow reasonable accommodations and modifications. And on that note, I'm going to pass it back over to Pete. Next slide.
Thanks, Alyssa. Where's the rest of the slide? There it comes. Okay. All right. So reasonable accommodations are practical and feasible, and they're changes in rules, policies, practices, or services so that a person with a disability will have an equal opportunity to use and enjoy a dwelling unit or a common area. So a couple of things about that. First of all, the term reasonable accommodations used under lots of laws, and it may have slightly different meanings. This is the Fair Housing Act meaning. In the Fair Housing Act, it applies to rules, policies, practices, or services. So it's not so much things, which you'll see under reasonable modification. Also, it applies to common areas. Person has to have the ability to use and enjoy common areas. Things like the clubhouse or the laundry or the pool area, anything like that. The Fair Housing Act and the Reasonable Accommodations section applies to that. Next slide, please. There are a few defenses for denying a requested accommodation. The first one is an undue financial and administrative burden. And HUD specifically uses that language to include both financial and administrative burden. Another one is if the accommodation is a fundamental alteration of the housing program. And important thing to remember is even if both of those above criteria are true, the housing provider must engage in a process to explore alternative accommodations that would give the person with a disability an equal opportunity to enjoy the housing or the common areas. So it's even if a particular there's a defense to a particular requested accommodation, got to look at other things that might provide that accommodation. Next slide, please. A reasonable modification under the Fair Housing Act is a structural modification. And it's made to allow the person with a disability to fully enjoy their housing and the related facilities. So again, it can apply either to the apartment or to the common areas. And it's made at the tenant's expense or on behalf of the tenant. So remember, it doesn't have to be, the tenant doesn't necessarily have to pay for it. And I'll just give you an example from a case I had where we had a tenant who used a wheelchair and needed a ramp to get into her apartment. She couldn't afford to build the ramp, but her church agreed to put in the ramp for her. The landlord was resisting, and she contacted us, and we got involved and were able to work it out so that the church was able to put in the ramp that she needed. Generally speaking, the landlord must allow the reasonable modifications. The landlord may require that the interior of the dwelling be restored to the original condition, but only if it's reasonable to do so. So if the tenant made a change that really wouldn't affect the usability of the apartment for a future tenant, or that would actually be an enhancement, as some of the modifications are, then it's not reasonable to put that back into that original condition and the landlord can't require it. But if it's a structural change that's going to really affect future tenants, then the landlord can, but doesn't have to, require the tenant to restore it to the original condition. Next slide, please. All right, examples. We've got several examples here that are reasonable accommodations or reasonable modifications. And I think that it's possible that some of these might be both. And so what I want to ask you guys to do is think about it. There's a reasonable accommodation or a reasonable modification. And that can be really important because that tells you who pays, the landlord or the tenant. Next slide, please. So tenant says, I noticed that you have a no pets policy. I wonder if I could have my cat with me in this apartment. She helps with my severe depression. So first of all, is that a reasonable accommodation or a reasonable modification? And if you want to I'll wait just a few seconds and you guys can put in the chat what your thoughts are. If you want to just put RA or RM, that would be fine. All right. See an accommodations company. Yeah.
Yeah, I think we're in agreement, Pete. And Pete, just checking in. I think you're good on time.
Okay, great, Aaron. Thank you.
Yeah.
Yeah, I think it's a reasonable accommodation. Alyssa, do you have a different thought on this one?
Sorry, couldn't unmute myself. I do not. Yeah, generally when an assistance animal question comes through, that's always treated as an accommodation.
Yeah. The one thing I would say about this is if you're asking for this kind of a reasonable accommodation, it could be very important to have some documentation from a professional, a counselor, a psychologist, a psychiatrist, somebody who can confirm that you have a mental illness and that this cat really provides, a therapeutic effect to help you out. Second one, I need smoke alarms that give a visual signal as I am deaf or hard of hearing. So what do you think? Reasonable accommodation or reasonable modification? Okay, I like that. Yeah, I'm seeing some boths in there. When I first saw this, I was really certain, yeah, this is a reasonable modification because you'd have to physically change out the smoke alarms. The more I thought about it, I thought, well, maybe it could be a reasonable accommodation too. What do you got any thoughts, Alyssa?
I mean, I think it depends on the property. It could be both. It could be something that you could just easily do. But if the property has rules about construction inside, it might be something that you have to ask for an accommodation in their policy. So it could be both. It just kind of depends on the property.
I think so. I think so. And those smoke alarms are not cheap. They cost something. So might be nice to get an accommodation out of it. All right. So next slide, please. A reserved parking space in front of the entrance to a unit, even though all parking is typically unreserved. So reasonable accommodation or reasonable modification? All right. Seeing some accommodations.
Mm-hmm.
Anybody think it might be a reasonable modification? I kind of think this one maybe, yeah, depends on if work needs to be done. Exactly. And I think, yeah, involves painting, exactly. So I think there's a real question in my mind whether even a de minimis cost, like painting somebody's name on the space or something, or the apartment number, would turn it into a reasonable modification, or if it's, just something that simple could be part of the reasonable accommodation the landlord could be required to do. What do you think, Alyssa?
I've never seen it as a modification personally.
Okay.
We've seen quite a few of these, and our interpretation of it is that painting of the parking lot is something that is typically the landlord or the association's responsibility. And so that's something that they can handle. If it's just painting, unit, whatever, on the space, whatever it is that it involves, typically is usually something that can be done for them with very minimal cost. And how the landlords handle it is different. Some of them will put up a sign. If that's what they want to do, then that's on them, because that's how they want to do it, So we have only processed them typically as an accommodation, and we've never had anyone make the argument that it was a financial burden to them to do it as a modification.
That's great. That's great. Yeah, I did a case involving a condo association, and they did try to argue that.
Oh, okay.
That the tenant, they wanted a sign, and they were wanting to require the tenant to put up a sign.
Mm-hmm.
So yeah, we worked through that, and I think they did agree to put it up. So next one, change of rent due dates to match disability checks. What you guys think? Accommodation or modification?
They were quick on this one.
Yeah, they're coming in fast. You guys are getting the hang of this. Yeah. Reasonable accommodation, I think so. And I think it's just a way of helping a person who's kind of living paycheck to paycheck to manage their funds. Sometimes the due date on the rent comes a few days before the checks, the disability checks due, and people who are living paycheck to paycheck like that run low on their money at the end of the month. And so it's a big help to them to have the rent come due right after they get their check, so they can pay it and then see how much they've got to last out the rest of the month. Next slide, please.
I want to note on that it should be the only source of income. If someone's got a disability check and the other person in the household has a full-time job, that's probably not going to line up as a necessity. But if the disability check is the only source of income into the household, then that's certainly, we have seen those cases before.
Yeah, that's a good point, Alyssa. It has to be needed because of the disability. Yeah. So a waiver of a requirement for previous rental history for a person coming out of an institution. Reasonable accommodation or modification? Yeah, jumping on that reasonable accommodation. Yeah. Okay. Yeah, I think so. I think so. Any thoughts or anything to add on that one, Alyssa?
No, I think you guys are right. This one's pretty clear cut. It's asking for a waiver of a policy or a procedure. So.
Yeah, exactly. So an alternate accessible mail delivery location that is acceptable to both the tenant and U.S. Postal Service. So what do you guys think? Accommodation or modification? Yeah.
Mm-hmm.
Oh, interesting. Yeah. Getting some different opinions here. I think I think it kind of depends on what's involved. It could certainly be both. If it's as simple as, slipping the mail under somebody's door or something like that, that doesn't really require structural modifications, then that's just a reasonable accommodation. But if it's, I think it would depend on how much construction or physical work is involved. What do you think, Alyssa?
I absolutely agree. I think this is another one that it kind of depends on the layout of the property and the situation. There's always, with modifications, there's always a little bit of chance that it could creep over into accommodations, depending on what policies are in place and what the property looks like and stuff. So this could be both.
Yeah.
I think I want to note too that this one could also kind of end up in that undue financial or administrative burden as well. We've seen cases where people ask that like the property manager deliver their mail personally. And that might be a situation where this is a great alternative to discuss if the landlord can't do that, if that's an alteration of their duties. This would be a good option to discuss a different place to drop it off.
Yeah. And it's, I don't know, I'd certainly want to talk with somebody who wanted the landlord to deliver it about, how much do you want your landlord to know all your business about your mail you're getting?
Yeah.
That's one of those things that goes a little beyond legal advice, but, I think it's something important to think about. So next slide. Install a ramp from the apartment door to the sidewalk. Yeah. Modification coming in. Yeah, I think so. I think that one got to be a modification. What do you think, Alyssa?
Yeah, I agree.
The one thing I would say about this, and it's kind of a related problem. I once represented a client in a very really nice neighborhood, and they had a homeowners association, and their house was up a bit of a steep incline from the mailbox, and both the folks there were elderly, and going down either through their yard or through the down the driveway was difficult and dangerous for them. And they put in, or wanted to put in, some steps with a nice handrail and everything so they could walk down and get their mail. And they got into a real dispute with the condo association about what the steps had to look like. And so it really became, about rules and policies, and not say, it was a reasonable modification, but they were perfectly able to afford it and could put it in, and they knew what they wanted, but they were fighting an accommodation battle with the homeowners association about what the rules were about steps in front of your house. Grab bars in the bathroom, in the apartment. Yeah, I think so. Reasonable modification. I think this is one of those, as we were talking about earlier, can the landlord require you to take them back out when you leave? Would it be reasonable for the landlord to require you to take them back out when you leave? I kind of think there's an argument no, because the grab bars, if they're installed properly and everything, that actually enhances the usability of the apartment for lots of folks. And it's not something that wouldn't make any sense, I don't think, for the landlord to require you to take out.
I agree. And I would argue if the landlord is pushing really hard for something that seems unreasonable, then that could also kind of be touching on that potential harassment and intimidation section of the law as well. You know, if they're, like I said, if it's unreasonable and they're really pushing for you to do that, then it could be a different violation.
Yeah, it could. So next slide, please. Install a ramp from the rental office door to the parking lot. And I'm going to say this is an on-site rental office. See a reasonable modification. ADA. Yes. Anything else? Any other thoughts? Okay. Yeah. I think under the Fair Housing Act, it's a reasonable modification. But assuming this is a private rental property, and you got a rental office, then Title III of the ADA might require that office to be accessible. If it's a public, then maybe Title II of the ADA would require it. The other thought is, what if going to the rental office was a requirement for the tenant to receive certain services? Would the landlord have to make a reasonable accommodation if, let's say, the tenant couldn't afford to put in the ramp and make their own modification? Would the landlord have to make an accommodation of, let's say, meeting the tenant in another place to do whatever needed to be done? Or let's say it's a prospective tenant who wants to apply for an apartment and needs to come in for an interview, and they can't get in the rental office. I think the landlord would have to make an accommodation to meet with that tenant in some accessible place. What do you think, Alyssa?
I absolutely agree. If it's not accessible, then they would need to find a way to still offer those same services. And that depends on what's in the office. If it's not possible to do that in an alternate location, then it might be something that they need to look into building themselves if the tenant can't afford it. And if it is open to the public, then that might be something they run into ADA issues as well.
Exactly.
If prospective tenants are allowed to come in, then that's open to the public because it's not just for the tenants existing. So they could certainly have ADA issues there.
Right, exactly. So install grab bars in the bathroom by the pool area. We're getting down toward the end. You guys are tired now.
I think your questions are getting trickier. That's the
okay. All right, here we go. Reasonable modifications. Yeah, I think it would be a reasonable modification. I mean, I'm assuming this is a bathroom that's open to the tenants and other folks in the pool area. And yeah, if this is a tenant who needs those grab bars, they could make that modification. You know, thoughts, Alyssa?
Nailed it.
All right. Next slide, please. All right, so a couple of other laws that come up in the housing area, and we're not going to talk about these in any detail, but I just wanted to mention them. We talked about one in the ADA, and I'll talk about that on the next slide. But Section 504 of the Rehabilitation Act of 1973 is related to the receipt of federal financial assistance, and it prohibits discrimination based on disability. It requires reasonable modifications and accommodations and non-discrimination and lots of other things. An example of places where it might apply: public housing. Privately owned dwellings that receive federal funding for assistance with construction, Section 8, things like that. If there's that kind of support, then Section 504 applies and can be an important tool that can help in addition to the Fair Housing Act commitments. Next slide, please.
I want to jump in real fast and note that
Please
that
do.
does not apply to tenants with Section 8 vouchers that travel with them. HUD does not
exactly right.
consider that to fall under the 504.
That's right. HUD made a decision long ago that that would not be federal funding. And so the actual receipt of a payment for the rent in terms of a voucher from HUD does not equal federal funding. It's the construction help that can be federal funding. Title II of the ADA applies to public entities, which is different from public accommodations. Public entities are like state or local government. And so some examples would be housing authorities, public housing, housing on a state university campus. Those are some of the examples. I'm sure there are some others. And Title II is again broader than just housing. And so it would be a complement to the Fair Housing Act amendments. Title III, which we were talking about earlier, applies to public accommodations. And so that's places like a rental office that are open to the public. The other place it might come up in housing is if somebody was operating a business out of an apartment or a condo. You know, let's say all the condos are housing except this one, and this one person operates a little I don't know, jewelry shop out of the condo. Then that particular condo would be subject to Title III of the ADA as a public accommodation. Next slide. Listen.
This is just a little bit about us and kind of how our process works as the commission. This is our toll-free number if you'd like to get more information or talk to someone about the law a little more specifically. Again, we don't give legal advice, but we can certainly talk to you all day long about the law itself and what we've seen. And I think this will all be available later as well. Next slide. This is to file a complaint, you can contact us by phone, by email, and there's also a way to file complaints on our website directly. You're also welcome to come in person if you feel better sitting down and talking to a person directly. You know, if you want to help explain a little better. There is always someone from all the departments for intake in the office between 8:30 and 5 p.m. every day. I will warn you that we are across from the State House, so it's all metered parking. so be aware if there's an event at the State House, parking can be a little difficult. Next slide, please. Now, if you're interested in filing a housing discrimination complaint, you would be referred to as the complainant. Complainants have 180 days from the last discriminatory action to file a complaint with us. The last discriminatory action is sometimes a moving target. If there was a specific date that something happened, say it was harassment, then that was, you know, the date that happened would be the last date of the discriminatory action. If it's something that's ongoing, such as being denied an accommodation request and it still hasn't been granted, then that could be something that's considered ongoing. And that 180 days is a little bit, like I said, a little bit of a moving target. If you're for some reason outside of that 180 days and can't file with us, you have a year to file with HUD. Their process is pretty much the same as ours. Like I said, the fair housing law and the South Carolina state law are pretty similar, and our regulations and how we operate are pretty much the same. If for some reason you're outside of that, or if you just don't want to go through us and you want to go ahead and file your own case in federal court, in that case, you have 2 years. And if you do file with us or with HUD, that timeline of 2 years to file pauses during the course of the investigation. So if you choose to file with us and then decide to go to court later, the time that it was in our hands does not count towards that. So you're not penalized if you go through us first.
Oh,
Next
Alyssa,
slide. Go ahead.
could I ask you a question?
Mhm.
I guess two, I mean, one is a question, one is a statement. The statement is you don't have to file before going to federal court. You don't have to
No.
exhaust your remedies. But the question is, doesn't HUD sometimes, you know, if you file a complaint with HUD, don't they sometimes send the complaints to you guys for processing?
Yes, and that's part of our relationship with HUD. We kind of refer cases back and forth. If they have certain federal funding on the properties, then we might refer it to HUD, or if it's over that 180 days for us, we might refer it to HUD. If we have jurisdiction, it's within our time frame, it happened in South Carolina, then it's probably going to come to us. Even if you file with them first, if we have jurisdiction, they'll probably send it to us for investigation. They pretty much let us handle almost all the cases through South Carolina, and there are a lot, unfortunately. Next slide, please. Just a quick overview of our process if you do choose to file with us. And like I said, HUD kind of does this very similarly. As soon as you put a case through intake, talk to us, go online, whatever it is, however you contact us. If we determine we have jurisdiction, then we will begin an investigation. That investigation can have a couple of different outcomes. We do try to encourage parties to settle. So if you come into it knowing what you're looking for to try to fix this, your investigator will try to help mediate that with your housing provider or whoever it is, and try to get a settlement. And if it settles, then we can have a legally binding closure agreement, and the commission can then enforce that agreement. If we somehow during the investigation find we didn't have jurisdiction, or if the person who filed kind of disappears on us and doesn't cooperate or something, that's what we call an administrative closure over there. And that just means that either we didn't have jurisdiction or we couldn't get in touch with the person, so we had to close out our investigation. The most common one is that we do an internal review of the findings and make a determination as to whether the commission feels the law was violated. And those two potential outcomes are no reasonable cause, meaning we didn't find enough evidence that there was a violation for us to take it to court. But the person who filed has every right to take that to court on their own if they feel differently. Since we don't represent anybody during the course of the investigation, it's not required to file with us, people can take the case to court at any point during the investigation or after, whatever they want to do. The other potential outcome is cause, and that's in red because that means we found discrimination, and we are going to take it to court on behalf of the state of South Carolina. So if you see where we've done any court cases, it says that we are filing on behalf of the state of South Carolina as the law enforcement agency. And at that point, then you would have the choice of whether you want to get your own attorney to represent you in that, or have our attorney also assist you along the way. And that's the point when you can start talking to one of our attorneys for a little bit more guidance. All right, I think that's kind of that's the quick overview of how our process works. This makes it look a lot simpler than it probably is if you were to talk to us. When you file a complaint, we'll throw a lot more information at you. But this is the simplified version. And I think there are a lot more other resources out there. If you'll move to the next slide, we'll talk a little bit more about other resources, not just us.
Yeah, these are a couple of my favorites. They're a little bit older, but HUD and DOJ did these, maybe 15 years ago, roughly, on reasonable accommodation and reasonable modification, and they're available on the HUD website. I put the links there. Next slide, please. I'm sorry, could we have the next slide, please? There we go. And these are just some resources and other agencies that you might consider reaching out to. Able South Carolina is a center for independent living that helps people with disabilities in lots of areas, including housing. South Carolina Legal Services provides representation to people of very low income, including in housing cases. I used to be an old legal services attorney, and I did a lot of housing cases back in those days. Some disability related, but often not. Appleseed Legal Services does a lot of good work in housing and other areas. And Lawyers for Vets is one of their services specifically for veterans. And then if you wanted to have a private attorney to represent you in a housing matter and you don't know of one, you can contact the South Carolina Bar Lawyer Referral Service. Next slide, please. And there's our contact info at Disability Rights South Carolina. So I think we got a little time for questions.
And while those questions come in, we actually had one in the middle of the session about walk-in showers, whether or not that would constitute a reasonable modification. And while you're mulling that over, I want to encourage everybody, there's a link in the chat to a survey. It really helps us out if you'll fill that out at the end of the session. Go ahead, take it away.
Well, walk-in showers sound to me like a reasonable modification that would be at the tenant's expense or not at the landlord's expense. What do you think, Alyssa?
I think, yeah, that sounds like it to me. The only thing I can think that would turn into, the accommodation would be if there are construction rules or something like that, that you'd have to talk to your provider about.
Right, so it might be both.
It could always be both when it comes to modification.
Yeah.
And Val asked if we can share the slides. Because we didn't require a registration, we don't have contact information for you guys to share the slides. But Maggie has put up a link to the resources in the chat, and this will be on our website, this presentation. And all of these resources are kind of on our website in different places. And Val, feel free to send me an email and I'll send you the slides. Send me an email and I can send out individual slides, but you are going to have to request it because we don't have your emails. So I'll be glad to do that.
Yeah, and someone asked about us being a law enforcement agency. We're not cops necessarily. That's what you're thinking. We don't have vests or anything, but yeah, we are tasked with enforcing civil rights in the state. So that includes the employment laws that are similar to equal employment laws federally. So our agency also works with the EEOC on state laws. And we also do a little bit in terms of public accommodations locally. So when I say law enforcement, it's not quite the same, but we are technically tasked with law enforcement for civil rights on behalf of the state.
All right, guys, and I think that takes us perfectly to 1 p.m. So thank you to our presenters. Thank you everyone for attending, and be on the lookout for for this on our website where you can replay this. Thanks, guys.
Thanks, everyone.
Thank you all.
Bye.